And law is about what you practice in court. You should have the patience and you should have the ability to learn. The 3-4 things which you have to learn in college or learn from yourself is 1, patience; 2, ability to adapt; 3, team player, being a team player; 4, learning from your seniors, learning observations and research capacity, and build up a hunger, willingness to learn and willingness to work hard and not give up.
Hello everyone, welcome to the next episode of WhyLaw powered by Bettering Results. In this episode, we are joined by a seasoned advocate who brings a wealth of experience in different legal domains, including constitutional law, civil law, taxation laws, arbitration, criminal laws, and many more. We are pleased to have Mr. Swarnendu Chatterjee here with us, who is an advocate on record in the Supreme Court of India and founder of Chambers of Swarnendu Chatterjee. Not content with his expertise, Mr. Swarnendu Chatterjee chose a rigorous path of becoming an advocate on record, a distinction which is earned through dedication, hard work, and perseverance. In today's episode, we'll be exploring the wisdom and journey of Mr. Swarnendu Chatterjee, a prominent legal figure. So make sure you stay tuned till the end of the episode. So before we start, would you give a brief overview of your life?
See, giving a brief overview about my life would mean I would start from my school days in Calcutta and thereafter my college days in Bhubaneswar. Back then, around 25 years ago, life wasn't so complicated like now. And in school, it was more of fun, but still, you have to go through the rigors and rigmarole of life. And that time, every time challenges are different. In school, you have different set of challenges. In college, you have different set of challenges. And in profession, you have different set of challenges. Giving a brief background, I come from a lawyer's family. My father is a designated senior of Calcutta High Court. And from my childhood days, I have seen clients coming in. I was very intrigued as to how my father would handle those clients and all. That time, Calcutta High Court was a very vibrant High Court. And now also the cases go on, but due to different set of factors and different set of different set of things and many factors, the High Court again is back in news. But you see, the kind of matters which used to happen back then, judgments we read, those judgments are seldom found coming from such a prestigious High Court. Now thereafter, different set of challenges in college, where it's home away from home. You get accustomed to the hostel life, then college life, studying on your own, and thereafter professional life. All of a sudden you are on your own in Delhi, starting from really a scratch and building up to here. It takes time. It's not a T20 match, it's a test match. You have to have your patience, that's all.
So as far as we know, in your school days, you had interest in economics and chartered accountant. So sir, what made you shift from this to choosing the field of law?
See, I was very close to my maternal uncle. He's an economist. As I was very close to him, I used to discuss a lot of issues. When I was growing up, I used to discuss a lot of issues regarding economics and read or go through economic times. And I was also a student of economics in school. So he used to explain a lot of theories. So those theories and the subject intrigued me, and I wanted to study that subject because it's one of the subjects or a field where you can examine the polity, the social strata, legal fraternity, fiscal policies. Basically, it is studying the heart of the country, even though you are not studying philosophy. So you get to know every other thing. You study every other thing. And chartered accountancy, because I was good in accounts during school days. So for that, I thought I would do. And in those days, in Calcutta, the morning shift of St. Xavier's was very famous. So I thought that why not try a shift over there, to try and shift my focus on that field. because it's a professional field. But ultimately, life with its twists and turns made me an advocate. So far, so good.
So how did your early experience in the legal profession under the senior distinguished mentors like late Shri P.P. Rao and P.S. Narasimha helped in your legal career?
Oh, it helped a lot. What do I say? I joined Sir's chambers, in his late Shri P.P. Rao's chambers in November 2013. At that time, I had no idea as to how work life will be. I had read and studied cases like S.R. Bommai and A.R. Antule in college, and he had appeared in all those cases. So I was seeing God in front of me, who had argued those cases of magnitude. Like me, it doesn't happen always. You make a 7-judge bench of Supreme Court overturn a judgment of 5-judge bench in a span of 1 year or a couple of years, and that too in a political case like that. Anyhow, but he was a very hard taskmaster. We juniors had to work shoulder to shoulder. The chamber timings were 8 a.m. in the morning till late in the night. In between, we used to get a couple of hours of break. But that schedule, that work life, was tremendously tough. And Delhi has all kinds of weathers. In winters, 8 a.m. means 8 a.m. Reaching chamber at 8 a.m. nowadays is very tough, and then also it was very tough. So it took me some time to get acclimatized to that office. But Sir was gracious enough to grant me that. And then it took off, and I had a fantastic experience. Whatever I am today is because of that great man. Like, if my father is one of my inspirations, Mr. Rao is a maker of whatever I am today. Like my profession, my life, my gait, how I conduct myself, the way to show my skills is all because of him. He has trained me today. And when Sir passed away in 2017, it was a big shock to me, because by that time I was trying to make a foot in the chamber as well as in the profession, and slowly clients were also recognizing me. But as God would have it, Sir passed away. But then another, as per his name, he, like Lord Vishnu's avatar, he came and he rescued me at that point of time. A great man and a great mentor. Now, obviously, a sitting judge of Honorable Supreme Court of India, Sir has been very kind, and he has always been kind to all his juniors. And because of these two stalwarts, I was able to clear AOR exam in one chance, that too with flying colors, and training which I got there. And I trained myself. That time I used to get very angry, jittery, that why so much of rigors and everything, so hard work, and the work-life balance is zero, nothing, so much of hard work, continuous work, no Sundays, no Saturdays. But now I get what it was for them. When you have clients breathing on your shoulders, when you have stakes on your shoulders, you cannot have even 5 minutes break. That's what makes you a great lawyer, not a good lawyer.
So, given your father's esteemed reputation as a senior advocate practicing in the High Court of Calcutta, and you being the second generation lawyer, so do you have any additional pressure of walking into his footsteps?
I never felt it. I've never felt it. My father has been my inspiration. Like, he has always inspired me to work well. Only thing he told me when I was coming to Delhi, that you have to be an advocate on record. That is my dream. And you have to work honestly, work hard. No matter how much money you make, you must be honest to your profession. So I have followed whatever he has said till date. And my father has been a backbone for me everywhere. Now, I have somewhat put my footsteps in Delhi. I'm an advocate on record. I have reached here with twists and turns due to the blessings of my father, my late senior, and my other colleagues and seniors in the profession. But the contribution of my father, my mother, and my sister cannot be forgotten. As my parents, they have sacrificed their time, their togetherness, cause of me many times, and to make me what I am today, they have sacrificed a lot. So I haven't felt any pressure due to the fact that I'm a second generation lawyer or I have to fill in the great shoes of my father. No. And because of such an apprehension maybe, and to make me a better lawyer, a tinge better maybe as per his words, he had sent me to Delhi to get the training, to smell the raw dust. Then only, until and unless you smell the raw dust, you cannot enjoy champagne at the tip of Mount Everest.
So, talking about your expertise in IBC, NCLT, NCLT, could you shed some light on some of the memorable cases or notable cases which you have experienced in your legal career?
Every case has its own history and its own twists and turns. The cases which I would like to share, or which is worth mentioning till date, is the Mozarbeer case. That's the first case I did. Around 100 crores of gratuity was at stake. I'm happy that I could win that case for them, and the court gave a verdict. That has become the law of the land because we won up to Honorable Supreme Court. With respect to the liquidation part, qua gratuity, the law became settled. But the law which was not settled was law qua payment of gratuity and provident fund when it came to the resolution plans. That got settled in Jet Airways case. I'm happy that I could be a part of that momentous occasion, that is 21st October 2022, when NCLAT gave that historic verdict which was upheld by Supreme Court on 30th January 2023. It was a momentous exercise, and there are other cases also in NCLAT and in NCLT which have been quite good, which have been followed up to Supreme Court. And with every passing case, I believe that every case is a memorable one if you want to make it a memorable one. Either your hard work will be memorable, irrespective of the outcome. It is not the lawyer who wins or loses, it is the client who wins or loses. We are only their hired guns, maybe.
So, apart from NCLT cases and IBC cases, we have heard a lot about you regarding notable cases in High Court and Supreme Court. So, can you give some examples of those cases as well?
Yeah. See, in every lawyer's life, there will be one such occasion or one such case or a couple of such occasions which keep on coming back. One such case was a case which had come from Punjab Haryana High Court. During the vacations, the interim order or the interim protection of that person got vacated. And the person was detained in a police station, detained by, I think, international, some investigation bureau because he was traveling from Calcutta to Bangladesh by train. And he wasn't aware there was a red corner notice. Nobody is aware that there is a red corner notice against him, and there is a lookout circular against him, and LOC issued. So he was detained, and Haryana police was going to arrest him. So what he requested, his colleagues requested me that whatever said and done, please have the SLP listed in Supreme Court. I have a stay of arrest. That day, Justice Rastogi, it was listed before Justice Rastogi, and we were being led by Mr. Siddharth Bhatnagar, senior advocate. In the first round, sir was busy somewhere, so I had to argue partially. But they said that, okay, we'll hear Mr. Bhatnagar on this. He is a very benevolent judge, Justice Rastogi. So it was arising from 138 matter, 138 dispute. So ultimately, we could convince him on the monetary aspect, and he stayed the rest. But the intriguing part is, the court sat from 4:15 till 4:45, and on our request, the order was out by 5:15. And our local counsel there in Kolkata made the judge, the local magistrate, wait because the case was being argued by us in Supreme Court. And once it was done, it gave us a lot of satisfaction that we could get a man free from from the clutches. The man will go home and sleep on his own bed. That is a lot of satisfaction, irrespective of the amount of fees you get. There are other cases which have been quite memorable. One, like some of the arbitration cases which we have won up to Supreme Court. This is some cases of cinema halls, like cinema hall distributors, or cinema hall owners. They were facing a lot of problems because their tenants were not paying because of COVID and after COVID. Now, because of that, there were series of litigations. So one such litigation had come to me. So we presented the client before multi forums. Like one set of matters were before NCLT Bombay, then NCLAT. One set of matters before Delhi High Court up to Supreme Court. Now finally we could get the properties free from those clutches, and ultimately today the halls are running in a running condition. So therefore we are more than happy with getting justice delivered. Maybe a little late, but justice is getting delivered. People have to have their patience. And in our profession, every day something memorable happens. So as we go on in life, there will be cases which are more and more memorable. But these sort of cases will always be etched in your memory. If I can tell you, if I have to tell you, I have to tell you about the Jet Airways hearing also in Supreme Court against the verdict of an Honorable NCLAT. The SRA had appealed against the inclusion of gratuity amount and all in the resolution plan. The SRA had appealed before the Supreme Court, and the appeal was dismissed in less than 60 seconds. So it was, and it paved the way for a new jurisprudence. And so many workmen became happy because it was really a pathetic moment till that time, because people did not know where their hard-earned money will go. PF and gratuity are never assets of any company. They are the hard-earned money which is kept as a deposit, which you will get on your demand or on your superannuation, or when the company will close down. You cannot deny it or use it as an asset of the company. So those are few memorable cases, and every day we do some of the other cases where one or the other points of law get decided. So you feel happy about it.
Sir, talking about these memorable and notable cases, how do you deal with the emotional toll that is sometimes associated with these cases, especially in the field of law associated with livelihood and employment issues?
Sometimes you walk into the shoes of the client. That's a problem. We can't hold back. But as a professional, we must remember we should not walk into the shoes of the client. You have to fight for justice. But sometimes for getting justice, you have to show the pain and ethos of the client itself. And sometimes you get too involved. So it's a problem, but we have to balance it out. And the first training which we get as an advocate on record is to how to be a partisan advocate, a zealous one, and also not to walk into the shoes of the client. Like Caroline style, we were asked to read Caroline's trial by Lord Brougham. So there, zealous advocacy, not walking into the shoes of the client. These were a part of our course. So basically, and the training given by my seniors were also never walk into the shoes of the client. The moment you walk into the shoes of the client, you lose that case.
So talking about your experience at the Supreme Court and the Honorable High Courts, you have tens and tens of cases listed every day. So sir, how do you prepare for these cases? I mean, do we have to read the entire case files again before the case proceeds? Or, I mean, what's the blueprint behind this?
The blueprint behind this is nothing like Herculean. The moment you get a file, the first time you prepare it, you have a note ready, a ready reckoner type, so important pages marked. Your file should be marked, updated with all the orders. From the first hearing when it happens till the last hearing, you should have everything on record, the judgments and all. Just have your note ready. And most importantly, to be a successful advocate, you have to have your retention capacity. A good one, a good retention capacity. Otherwise, you will not be able to succeed. So therefore, my mantra is that whenever I have more than 3, 4, 5 matters listed before different forums, I go through the notes an evening prior or in the morning, so that everything is in my mind, and just I flip through the pages. But one should be aware that at least once, twice, you should refresh yourself with the case laws, with the file, so that you don't fumble in front of the judge. You should not look underprepared before any judge. And you should not come out of the court saying that I could have done better. These 3 things are very important. Once you are through it, then you will know how to do it. In fact, when we grow more in the profession, we will have 10, 15, 20 cases. Does that mean you read 10 cases every day? You don't have such time. You hold conferences, you go for conferences. The mantra is you should have your note ready, so that at least you flip through the note, you have your page numbers ready, and you have the things in your mind, what to argue, how to frame. You constantly have your mind working. So by that, you get trained. That is why the rigorous training.
So talking about the case laws, how do you manage to keep yourself updated with the changing laws and the legal precedents, and what do you do for keeping yourself updated?
Nowadays, it's not tough. You see, nowadays you have WhyLaw, bar and bench, news feeds, this, that, SEC, everything. It comes on mobile alerts. It comes as a alert on your email. So you can easily see it and keep yourself updated. It's not a Herculean task to keep yourself updated. Even if you have passion and hunger in the profession, then you will be able to do it. See, as late Mr. Jetmalani had said, this profession is a zealous mistress. The more you give, the more it will demand. But it will not leave you.
Right.
It is a zealous mistress. It is a zealous mistress. It is a jealous one, but it will never leave you.
So as an advocate on record, what are the key responsibilities that come with this designation, and what are the perks associated with this role?
First of all, I would like to state here, an advocate on record is not a notary. You walk up to an AOR and say, people have that idea that I'll do an AOR, I'll draft and I'll do everything, and I'll get an AOR, he will just sign and we'll file. Some people have done that and they have got reprimanded by the court. Now Supreme Court is coming down heavily on such practice. AORs are nervous system of the Supreme Court. We go through rigorous process to become AORs. We write such a tough examination where pass percentage is 10, 15, 20 maximum. It's one of the toughest bar exam. If you compare in that the world level or at the level of Asian countries. And then if you just sign for 2,000, 3,000 rupees, it doesn't make up to that mark or the designation which Supreme Court has honored or coveted on you. You should be extremely responsible, because you are the one who is married to the brief. You are the one who is responsible to the court. You are the officer of the Supreme Court, the highest court of the land. And you have a duty cast on you to scan through every pleading, every paper, because you are signing. It's not a signature, mere signature, like a notary.
So can we say with great power comes great responsibility?
Yes, absolutely. And such practices of just signing and showing off responsibilities should immediately stop. Like Supreme Court is saying over and over again, AORs should be responsible. What kind of cases will come? Because if you get frivolous cases to you, it is not about money every time. It's about reputation also. Nowadays, press is so active. Online, Twitter, WhyLaw, bar and bench, this, that. Sometimes it's not your guilt because the client tells you. But it is your duty to make the client understand that, see, this is a frivolous one. Court will dismiss it. Maybe you won't do it. Somebody else will do it. That can be an argument. But at least you don't do it. No, the client will then come back to you sometimes and say, that, okay, no, you were right at that point of time. So AORs play a key role when it comes to filing of cases in Supreme Court, arguing cases in Supreme Court, drafting of cases in Supreme Court. You have to have that legal eagle's eye, a prism through which the muslin will pass.
So since you had cleared your AOR exam in the very first go, so can you share some of the tips and the guiding lessons for the aspiring AORs?
See, the major thing is you have to be extremely focused. Second is, though Supreme Court is now introducing online platform, online examination system, but I don't know about it much, so not comment. I won't comment. But if you are opting for the writing one, there's a like you're sitting and writing, then you should practice time in a time bound manner. You finish answers, 35 minutes or 40 minutes per answer. And you will have to study, you will have to at least devote 2 months to study for that paper. Here also my father had played a very important role. He did not make me sit and study. He said, you have to study this. This is how you have to prepare. I guess I have never given that exam, but this is how you have to prepare. Even Mr. Rao had said, even if you write 50 pages for an answer, but there are no key points to it which we are looking for. You won't get more than 15 on 25 or 13 on 25. But if you write 2 pages for a 25 mark answer, but all the key points are there, maybe you will get 21 or 22. So the key pointers for budding students who want to be budding lawyers who want to become AORs is that 1, practice writing in a time-bound manner. 2nd, study Supreme Court rules and practice and procedure well. Know your subjects well, like constitution and the procedural laws. And get into the habit of reading judgments in totality, not only the head notes. And do not think which is important and what is important. That happens in college, not here. Here the matters are serious. You're talking about serious stuff and not per se moods or competitions. It's life which you are talking about. So therefore, it's very important, and the perks involved, which you said, once you clear, then it is only you who can destroy your profession. People will say matters have to come to you. That is on you, because everybody gets one or the other opportunity. If you want to make a name for yourself, slog, work hard, make that one opportunity grow big for you.
So talking about the legal profession, is it true that a lawyer's job is not just 9 to 5 and it is a 24-hour job?
I'll correct you over there. It's not a job, it's a profession. The moment the thinking changes, 9 to 5 thing will go. You have to know that it's a profession, not a job. It's a 24-hour thing. Of course, you will have your food, you will have your time off and everything, rest. But during work, you have to think. It's your mind. It's all mind games. It's like late Mr. Nariman said, it's the advocacy which will win you cases in the court, and how you argue and present your cases, not only how much you study in your office. You have to prepare, you have to argue, and you have to know the method to argue, and you have to know whether you are connecting with the judges or not. You have to read their minds. It is a very difficult task. It's not at all a 9 to 5 thing. It's a profession which requires immense amount of patience and dedication.
So as seniors tell us that once you enter the office, you should not see your watch. You just have to work. So
it is true. It is true. But with today's generation and today's people, you hardly get that vibes, because then obviously security issues are also there for people because of the things around. But also apart from that, you have to brave it up. And sometimes you can work from home. You have digital files and everything. Even if you go home, you have research machines, you have research engines and everything. And you can, if you want to work, you can work. If you don't want to work, do not want to improve, then you may not improve at all.
So reflecting on your internship during your college days, you have had the experience of judicial clerkship at Kolkata High Court and interning at reputed law firms like Amarchand Mangaldas and Trilegal, etc. So, sir, What role do these internships play in one's legal career?
Oh, it builds a lot of confidence. Internships are not for fun. Internships are serious stuff. That's the major thing I try to inculcate in my interns, because sometimes they come from outstation and sometimes they come from Delhi. So whether they come from Delhi or they come from outside Delhi doesn't matter to me. The Because it is these are opportunities where you learn. You try and learn. If you don't want to learn, don't come. But here it's not a fun time, or it's a time to go around and smile and come back. No, see, things are, when you are into your final years, 4th year, 5th year, you should get serious about it. At least you should know what you are doing, what you want to do. And with seniors' blessings and seniors' guidance, you can go a long way.
So, sir, what should be the criteria that students should adopt while thinking about their internships? I mean, where should they start from introspecting their legal interests? So, can you just give them guidance?
They should first tell themselves that I won't see the money and choose my avocation. Just because people earn that, like people have an idea that moment I go to a law school, after that I'll join some big tier firm, top tier firm, and I'll earn in lakhs. It doesn't happen. It might happen to some. It might not happen to all. And law is about what you practice in court. You should have the patience and you should have the ability to learn. The 3-4 things which you have to learn in college or learn from yourself is: 1, patience; 2, ability to adapt; 3, being a team player; 4, learning from your seniors, learning from observations and research capacity, and build up a hunger, willingness to learn and willingness to work hard and not give up. That's what I even tell my interns, and so far in my independent days, I've got good interns. Apart barring 1 or 2 in the past, but more or less I choose my interns that way.
So, as a lifetime member of Indian Institute of Arbitration and Mediation, how do you see arbitration and mediation helping to reduce the burden of regular courts?
It depends on facts of every case. Whether it is reducing, whether it is not reducing, it's only for the records to state. It's not only about the record book. It's about parties' intentions. If the intention of the parties are not to settle, they will never settle, no matter how much you mediate. Of course, it's one of the ways now they're exploring pre-litigation mediation, arbitration, conciliation. And the institute you were talking about, IIAM, my friend Iram Majid, who has been kind enough and who is doing very good in this field, has recently written a book also. She made me a member over in this place, and she's a fantastic mediator and one of the pioneers in this field. And I feel that mediation has a long way to go and a great future in our country, because a lot of cases will get solved if people talk across the TV and leave their egos behind.
So, talking about your vast experience in dispute resolution, can you also share some of these notable cases which you have had the chance to experience in your legal career?
Every such case is a notable case. The Mozambique one, the Jet Airways one. When I was junior with Mr. Rao, then I was doing the ISKCON matter, the theological dispute which is pending in Supreme Court. Then there are cases, there are some criminal law matters which were memorable one. And some matters while I was in Luthra, there were some matters, there was a couple of criminal matters where we drafted an overnight writ criminal and got a stay of arrest from the High Court, and the person breathed reprieve. And there were other cases all there, and many such cases, memorable ones, which are etched in my memory. Like one of the cases being that of Dart Properties, where legal position of walking into the premises in case of breach of agreement, conciliated agreement, got settled up to Supreme Court. Then there are such cases which will be there. The list is endless.
So, talking about your legal journey, you started as a managing associate at LNL Partners to Principal Associate at Saraf and Partners, and now you have started your own practice at Chambers of Swarnendu Chatterjee. So, sir, what were the challenges you have faced while coming this far?
See, I have seen both the tables. Table as a junior to stalwarts in the profession to senior advocates. From there, I have learned court craft, research, patience, ability to sit long, ability to wither every challenge and work hard, work long without seeing the watch, as you said. And here, as a principal associate or a managing associate, what I learned, see, in Luthra, it was a great experience. My partner was just amazing, Wasim Beg. And even Rajiv sir used to adore me a lot. And even Mr. Sondi, late Mr. Sondi, people had questions about his temper. But of course, he was a temperamental person. God bless his soul. But he was a genuinely a great person. Like, I learned how to manage everything, how to manage clients, how to build a profession, how to earn, and how to gain revenue. All of these things. It doesn't matter how much you work hard, but not have the commercials in place. So you can work hard, but you should always focus on commercials as well. But it doesn't mean that if you are not getting paid well in some matter, you will leave that matter and go to another matter where they pay you well. No. Like my senior had stated, paying clients are your Anyadata and non-paying clients are your Bhagyavidata. Every client is important. But revenue is also important, because this is our bread and butter.
So, according to you, what role does the mentorship plays in building a successful legal career? And you still have a few mentors which you idolize?
Yes.
Apart from those which you have already mentioned?
Yes. I idolize Siddharth Bhatnagar sir, Malvika ma'am, Malvika Trivedi ma'am, great seniors, Meenakshi Arora ma'am, and Shyam Devan sir. A lot of people are there in the profession who have been really kind and who have always encouraged people like us who are reaching the middle path, 10, 11, 12, 13, 14 years of practice. And then you have like-minded people. They're not competitors. The moment you see each other as a competitor, you won't be able to learn. Somebody may be good in criminal, somebody may be good in arbitration, you may be good in civil, other may be good in insolvency. So brains must be put together. Once you learn from others, then you can put it to use as an advocate who has substantial practice. You must be able to solve the problems of your neighbor. Like as a teacher, you should always frame questions keeping the backbencher in mind. You should be a lawyer who not only knows hi-fi and high-end laws, but also should help a client who has received a 41A notice and help him by getting a reprieve for him. Be a common man's lawyer and also be a rich man's lawyer, but maintain parity.
So, sir, learning is a never-ending process in this profession.
Yes.
So, looking ahead, what goals and aspirations you have for your practice, and what legacy you hope to leave behind?
See, talking about legacy and talking about and you asked me a few minutes back, you had asked me that how do you mentor your budding AORs, or what are the tips? See, and what are the skills one should have? Now, a few days back, I was taking a class with you, taking a course wherein students were attending on Order 6, Rule 17 and Section 151 CPC with bettering results. And there are other platforms also where I'm consultant by teaching, where I'm teaching subjects relating to AOR examination, Supreme Court AOR examination. I always try and focus on the needs and the nitty-gritties, not exaggeration as to what and talk big. Basics should be clear. First principles should be clear. If you're clear on first principles, you should have a easy going. relatively easygoing. You should be focused in life, and by that legacy I mean that I should be able to convey to my juniors and the budding lawyers or the lawyers who have just entered in the profession. Have patience. Success will come. Do not judge a book by its cover only. That it is to, and don't go by a statement. Array litigation takes a lot of time. It will take 5 years, 10 years. For the beginning, for the first 5 years, maybe your friend who is working in a firm will earn more than you. But trust me, if you work well, when you are at the, when you have worked for 20 long years, and he has also worked for 20 years, you see and measure yourself where you are. I'm not asking for a lot about a competition, but you will have more peace of mind, because you are nobody. No, you are answerable to. You are not answerable to anybody except your clients. You will see, as a partner of a law firm also, you will have your buckets to fill. You will have your targets to meet. You will have your recoveries. So that's a tension, right? Who wants so much of tension in life? You work hard to enjoy life, not to have thousands of burdens on your shoulders. We have lots of burdens. Other people's burden we carry, right? So there, I want to advise, take it easy, take it slow. Do not rely on hearsay stuff. Taste it for yourself. Success is bound to come.
Thank you so much, sir, for your valuable insights. And it was an absolute honor for all of us and all our viewers. Thank you so much, sir.
Thank you.